Good morning and welcome to a new episode of Future of Europe. I am Ilona Nido and I'm delighted to welcome today Manon Vincenti, student at the Catholic University of Lille in the master's degree European Law and Litigation. Today we'll talk about a case that touches on critical legal questions of the COVID-19 pandemic, how to balance the need for public health measures with the protection of personal data. Thank you, Manon, for joining us today.
Thank you for having me.
So could you start by explaining the court's ruling?
Absolutely. So this case revolved around the Czech app, which the Czech Ministry of Health developed during the COVID-19 pandemic. The app was used to verify people's COVID-19 status, whether they were vaccinated, had recovered from the virus, or were recently tested. The main question before the court was whether the Czech application operation qualified as processing under the General Data Protection Regulation. The app scanned QR code from the EU digital COVID certificates, which contain sensitive personal data like a person's name, date of birth, and health status. This data was then displayed to verify compliance with public health requirements. The court ruled that this process clearly constituted processing under Article 4.2 of the GDPR. Action like scanning, converting data into readable format, and displaying compliance with health requirements involve automated operation on personal data, though they fall squarely within GDPR scope. However, the court went beyond this basic qualification to stress that public health measures involving personal data must respect GDPR principles, particularly proportionality and necessity. This wasn't just a question of whether the app processed data, it was about whether this processing struck the right balance between addressing the public health crisis and safeguarding individual privacy rights.
So the court had to weigh the urgency of a public health emergency against GDPR safeguards, but how did it approach this balance?
So building on that, the court analysis here was critical. It emphasized that even during a public health emergency like the COVID-19 pandemic, GDPR compliance isn't optional. The court applied two key principles, proportionality and data minimization. On proportionality, the court acknowledged the urgent need to control the pandemic and prevent further virus transmission. It determined that the app's design was proportionate because it processed only the minimum data necessary to verify compliance with public health rules. For example, the app didn't store or transmit data beyond the immediate purpose of the verification. This ensured that the intrusion into individuals' privacy was limited to what was strictly necessary. The court also highlighted data minimization, one of the core principles of the GDPR. The Czech app only displayed information relevant to the health check, name, birth date, and health status, nothing more. The app's limited scope played a significant role in convincing the court that the measure was justified. At the same time, the court underscored that emergency measures cannot become a justification for unrestricted access to sensitive personal data. Even in crisis, government must establish clear safeguards, such as ensuring the temporary nature of the measures to prevent any lasting harm to fundamental rights. This case builds on prior CJEU decisions like Schrems II and Digital Rights Ireland, where the court reiterated that measure infringing on privacy must always serve a legitimate aim, be strictly necessary, and not unreasonably interfere with fundamental rights.
But what does it mean for the GDPR and what broader impact could it have on handling future crises?
It's indeed hugely significant. This case demonstrates the resilience of the GDPR even under extraordinary circumstances, like a global pandemic. The court sent a clear message. Fundamental rights, such as privacy and data protection, cannot be ignored even during emergencies. One major takeaway is that the GDPR provides a flexible yet robust legal framework. By requiring proportionality and necessity, it ensures that emergency measures are time-limited and narrowly tailored. This is important because, as we saw with the Czech app, even well-intentioned measures can raise concerns about overreach if they are not properly designed and monitored. At the same time, the case highlighted areas where the GDPR and its enforcement could improve. For example, the European Data Protection Board had to issue guidelines reminding governments to prioritize privacy, but still enforcement varied across EU member states. This showed the need for greater harmonization and data protection practices during crisis. Looking ahead, this decision sets a precedent for addressing future challenges, whether they involve public health crises, technological advancement like AI, or climate-related emergencies. The court emphasis on temporary measures, strict safeguard, and the right of individuals will likely influence how data protection laws are applied in this context. Ultimately, this decision underscored that data protection isn't just a legal requirement, it's a fundamental right. By maintaining the balance between public interest and individual rights, the court helps ensure that we're prepared to handle future emergency without compromising on privacy.
Thank you. But beyond GDPR and public health, do you think this decision could influence other legal debates, particularly concerning legal technologies and data protection?
Yes, in a broader sense, this means the ruling is not just about COVID-19. It's about shaping the future of data protection in an increasingly data world. One of the most important areas where this ruling could have an impact is in AI-driven health monitoring and biometric data collection. Governments and private companies developing tools for health surveillance, digital identity verification, or AI-powered diagnostic must now ensure they comply with the same GDPR safeguards emphasized by the court in this case. The ruling also reinforces the growing importance of judicial oversight in the regulation of digital innovation. As new technologies emerge, whether it's facial recognition, automated decision-making, or cross-border data transfers, the court is likely to apply similar legal tests to ensure they respect fundamental rights. This means that just because a digital tool is useful doesn't mean it can bypass privacy protection. For example, the court's strict approach in the case Nordic Info highlights a consistent judicial trend. Whether in public health, AI, or commercial data processing, data protection must always be safeguarded. In this case, the CJEU reiterated that any restriction on data protection must meet strict necessity and proportionality criteria. This confirms that future technologies, such as AI-driven health tools and biometric databases, will face similar strict legal scrutiny to ensure GDPR compliance. In short, the RK case is not just about COVID-19, it's a key precedent in the evolving landscape of data protection. It sends a clear message that technological progress must always be balanced with individual rights and the legal framework of the GDPR. It will likely continue to play a central role in that balance. Thank you.
Well, thank you very much, Manon, for your answers and your time, and thank you to everyone for watching this episode of Future of Europe.